Okay, so thank you, Jonah, so much for taking the time to meet with me today and to discuss your practice for our negotiation class at the UCL School of Management. I was wondering if you could get started by introducing yourself, telling us just a little bit about who you are and what you do.
Sure. Yeah, I'm an attorney by trade. I graduated from law school back in 1980. And for about 30 years, I practiced with a firm what you would call complex litigation. We did large cases all across the country involving issues from securities claims, pension claims, insurance coverage, breach of contract. We really covered the gamut. That involved trial work, being in the courtroom, as well as writing briefs and handling appeals, all aspect of the litigation process. Then about 10 years ago, I began winding down that litigation practice and converting over to what we call alternative dispute resolution, which really has two categories: mediation, attempts to settle things out of court, and arbitration, which is like an adjudicatory proceeding, but is private. And so I now act as an arbitrator, hearing cases, and also act as a mediator. Probably my bigger emphasis is on mediation. That's really my sort of first passion for what I'm doing in this phase of my career.
So we've talked a little bit about these alternative dispute resolution practices in class. I would love to hear a couple comments from you on the distinction between the arbitration and the mediation. And since you said your core focus is more on the mediation, I'd love to hear more about why that is and how you see the whole picture.
Sure. Arbitration has developed here in the States, at least, as a way to do pretty much what you do in a courtroom, where you present your case and the parties eventually get a ruling from the arbitrator. But the thought was that if it was done outside of the courtroom, it could be done a little more quickly and a little more cheaply. So it's very much like a court proceeding. A complaint is filed, an answer is filed, there's discovery, and the arbitrator, the private party, such as me, who's been hired, rules on various motions before trial and eventually holds a trial with swearing in of witnesses and testimony and cross-examination. But the arbitrators are not bound by all of the court rules, the formal rules of civil procedure that we have and the formal rules of evidence. And they can do things, the theory is, more expeditiously. There's a lot of debate about whether it really ends up being cheaper and quicker, because the lawyers who are involved in the proceeding tend to end up pushing it back towards the same thing that happened in courts, but it still seems popular. Many, many business contracts and consumer contracts in the United States have a clause in there that says if the parties get into any sort of dispute, they must arbitrate it. So that's one aspect. It's very much like a court proceeding, but it's done privately through arbitrators.
So what do you think? Oh, sorry. I was going to ask, what do you think is it that leads to the popularity of arbitration and why it's so often in those clauses?
I think that particularly in consumer contracts, such as when you buy software or when you sign up with a bank or a broker, what arbitration does is it avoids the jury deciding things. And particularly corporate defendants are very concerned about juries getting sort of an emotional charge out of a case, out of a presentation of what happened to a plaintiff, rather than the facts, and awarding big verdicts. So in consumer contracts, it's definitely the ability to avoid going before a jury. In business to business, I think there are a couple of things that drive it. One, it's private. You can keep a mediation under wraps, whereas if it's filed in court, it becomes a public event. And the other event, I think, is even with business to business disputes, businesses tend to prefer to have a seasoned arbitrator, somebody who's been a lawyer for 30, 40 years, rule on something than rather have a jury rule on something. So you get back to that element of avoiding the jury as well in business to business cases.
And I'm curious to hear about the selection process in terms of who determines the arbitrator. Is there ever any concern about bias, or would you say that's generally a fair process?
Well, that's certainly a concern of the litigants. The major organization in the United States is called the American Arbitration Association, the AAA. Probably they hold the greatest number of arbitrations. That's where I'm on the panel of arbitrators. So what happens is the contract between the parties will usually require that they do an arbitration with the American Arbitration Association, which has a whole set of rules on arbitrator selection. Usually what happens is the American Arbitration Association looks at its pool of arbitrators to see who might be appropriate for a case, and they give the parties a list, a selection, and the parties can strike people from that list. And the hope is at the end of that process, that the arbitrator, there's one on the list or several on the list that are agreed upon. Sometimes for bigger cases, it's a 3-arbitrator panel. For smaller cases, it's a single arbitrator. So, there's a process, and I think it gives the lawyers a good chance to vet the arbitrators and try to avoid what they might perceive as a bias in one direction or another. And I don't hear that complaint too much that the arbitrators are biased. There are some complaints in the consumer arena that sometimes the arbitrators, because they do a lot of work in a particular industry, might be biased in favor of the industry. So there's some of that, but not too much.
So I think I cut you off. You're about to start talking about the other half of your work, the mediation side of things.
Yeah, mediation is entirely different than arbitration. Mediation is where two parties are in a dispute of any kind. They'd like to try to resolve it out of court between the parties, and they bring in a third party, the mediator, who acts as what we call a neutral. That means the third party has no stake in the outcome. The third party doesn't represent either side and is simply there to try to help the parties figure out how to resolve the case. And there are various techniques that are used, and that's a whole area that we could discuss. But mediation is the use of a third party. So the notion is the mediator almost never decides who's right or who's wrong or issues a ruling on the merits of the dispute. Mediator is there simply to try to get the parties to try to work something out, a settlement.
So I'd love to hear about some of the type, and I know you have to respect confidentiality, so you can't get into really any details, but I'd love to hear in a general sense about the types of cases that you personally have seen. And I'm curious as well, how these cases get to you. How do people decide whether to use mediation, whether to use arbitration, and then if they decide mediation, how does it end up in your firm's lap?
Yeah, well, how mediations end up before me is, that's fairly straightforward. In most cases, the sort of commercial cases, the person who selects the mediator is the lawyer rather than the client. This is something where the lawyers who are litigating a case in court will talk to each other. There'll be some interest in settlement, and one or the other lawyer will suggest, why don't we try a mediation? Because they think it might raise the probability of getting a settlement rather than the lawyers and the clients directly talking to each other. And it's simply, a personal knowledge basis. I get hired as a mediator because after 30 or 35 years of litigating, I know many, many lawyers in the Chicago community where I'm located, and I market myself. They all know that now I do mediation, and for certain cases, they may decide that I might be the appropriate mediator. What lawyers look for, sometimes they simply know you as a personality. They think you'll be a good person to settle cases. Sometimes they look for subject matter expertise. They look for the fact that you know a lot about the area of law that's involved in a particular case.
This sounds like it's often the lawyers who are making the suggestion, hey, maybe we can go to mediation. If you had to guess, I mean, have limited perspective, how do you think their clients perceive it? So people, the people working for the companies, the people outside the ADR world, do you think they like to go to mediation, or do you see the lawyers really having to strong arm them into the room?
I would sort of put that in two categories. A lot of times the client is represented by an in-house counsel. And an in-house counsel, a general counsel who is a lawyer, will be very familiar with alternative dispute resolution. And that may be the driving force rather than the lawyer, or if it's the lawyer who suggests it, they're very familiar with it. But if you don't have an in-house counsel, if you're just dealing with a corporate executive, they may or may not be familiar with it, but I think largely they probably rely on their lawyer's recommendation on that. If they're interested in settling and the lawyer says the use of a mediator might increase our chances of settling, I think most clients probably accept it.
So what are the kinds of cases that you see and mediate?
Yeah, it's a pretty broad swath, so I'll rattle off a few of the sort of things I've seen. Certainly employment disputes, executives who've been terminated, some class actions, consumer claims, where there's a representative party that's representing thousands or hundreds of thousands of consumers suing a company for some wrongdoing. Insurance coverage, that's where somebody feels they're entitled to more money under their insurance policy than the insurance company is offering. I've done cases in the securities field to a dispute between a client of a stockbroker and the broker, claiming that the broker made certain errors that caused them harm. I've unraveled partnerships where people get into a business transaction together, either through a partnership or a corporate entity, and they have a falling out, usually a personal falling out, and they need to unwind their affairs. They need to sort of go their separate ways. Who's going to continue the business? Who's going to buy who out? Who's going to walk away? Or are they both going to walk away? That's a pretty common subject.
So is that one is that the type of thing that can still wrap up in like a half day or a full day session? That sounds like a pretty complicated kind of case.
Well, it depends. It can be or cannot be. I would say that the typical commercial mediation takes a day. If you've got a really complex case with high stakes, tens of millions at issue, then they sometimes go 2 days, or sometimes you have a session and then a few weeks later. But the typical case is a day. Maybe you get done in half a day, maybe you don't, but that's what you normally set aside.
So I'm wondering if there are any cases from your experience that come to mind where you really felt like the mediation added value. I mean, you know, I'm sure the mediation added value in most, if not all of your cases, but my experience as a mediator is sometimes you get this sense of like, I'm here in the room, but you know, they're carrying it along pretty well. And sometimes you get the sense that you're really doing work in terms of helping them unpack the issue. And you can see that it, you know, turned out very differently as a result of your involvement. I was wondering if anything comes to mind, and if so, if you could tell us about one or two of those.
Sure. Yeah, I think I know one example. I mediated a case. It was, I can give some of the, you know, broad outlines. It was a pension case where a former employee who'd been involved while he was with this company with the pension plan, so he knew a lot about it, thought that the company made a sort of switch in how they were interpreting the rules of a pension plan right at the same time they had a big reduction in force, and it ended up lowering the value of the pensions for all the people who lost their jobs at the reduction in force. And so he brought suit to try to rectify that, and they largely worked out a rectification, but there was still a lot of disputes at the end there, particularly over the attorney's fees for the lawyers. And the problem in that case was there was tremendous animosity by the plaintiff against this company because he had worked there for many years. He had been involved in the pension plan. He knew it intimately, and he really thought that there was just an attempt to take away money from the employees rather crudely. The company, on the other hand, really had a surprising amount of animosity for this ex-employee because I guess he'd talked to current employees about what was going on, and they thought that he was really causing trouble beyond what he needed to for his case. So there was just the animosity made it, and the animosity spilled over to the lawyers. The person in the mediation who was really representing the company, they had outside counsel, but there was an inside lawyer who really, really hated this plaintiff. And the plaintiff really, really hated the company. So it made it difficult for them to make concessions in the negotiations because they just felt they were conceding to somebody that they really hated. And it just took a lot of cajoling and, you know, a lot of talking through, well, you know, you may feel this way about the person, but look how much it's going to cost you to fight this case in court. The outcomes are uncertain, you know, and go through all the rational negatives of proceeding to resolve these remaining issues through litigation. And just hammering that over and over again and pushing them to keep moving, don't walk out of the room, don't stop talking. And eventually they reached a resolution. So that was sort of phase one, where there's no question that having a mediator got the parties to resolve things. And there was a phase two as well, when the parties are trying to put together the full agreement, which doesn't happen the day of the mediation. And they were at issue over a number of terms and provisions in the settlement contract that weren't all that important, but they had all genuine disputes about them. And I finally realized that the reason they were fighting these small, somewhat less important clauses was because they just hated giving in to the other side. And so eventually I just said, here's my suggested resolution of all these terms and conditions. Clause A should read this way, clause B should read this way. And because it came from me, somebody they at this point trusted and respected, not from the person they disliked, they accepted it within about, you know, a matter of hours. So that was another way the mediator was able to sort of help.
Sounds like you were in these examples. There's a couple things you're doing. One, in that first phase you mentioned, it sounded like there was a big role just for building understanding in terms of understanding the situation and each other, which of course is something that we've talked a lot about in this class. You know, we talk about communication skills and things like that. It sounds like in the second example, there was sort of an inherent value of just having this like third person perspective in the room, to be there and to say things that were on the table so that people could hear it from a perceived neutral perspective. Is that right?
Yeah, although, this was largely done in caucus, the way most commercial mediation. So I was largely talking to each side. And I think what you're really doing is you're helping each side be their better self.
Okay.
This is not where, it's not like negotiating a deal where there's a transaction that both sides want to get done. They have a courtroom and they can go to it and they both think that, well, I'm going to win in courtroom, or I'm going to do better in the courtroom. But nonetheless, there are many, many advantages to settling it without using the court process. And so you really just have to make people focus on that.
That actually reminds me of something that I know you and I have talked about before, but I'd love to hear you comment on it now. This notion of both sides always think that if they go to court, they're going to get their outcome. And I think I've even heard you mention in some of our conversations, if you talk to both sides and both sides lawyers think, oh, I'm 100% sure that the judge will rule my way. I'd love to hear you comment on how that looks from your perspective. I mean, you're an attorney, you're a mediator, you've kind of seen all sides of things at this point.
Yeah, it's a very interesting phenomenon. Not only do you sometimes see both parties thinking they're likely to win, but one party will say, not only do we know we're going to win, but the other party knows it. They're just making up this claim to try to hold us up for some money. And then the other side will say, the other side knows they can't win. And both sides have these dramatically divergent views. I think from the client's point of view, it is just the classic case of a factual situation where two people can have vastly different views of the situation and just can't perceive how somebody could view the situation differently, even though a neutral can see that it's really a close call. It's not a black and white situation, but they're so angry that and then the lawyers are in a bit of a difficult position because they have to walk a line between helping their clients get through this problem in the best way, whether it's settling or going to court, but also presenting themselves as good warriors for their client. They do want to tell their client, look, if we go to court, I think we got a real good case. I can do it for you. I can really help you get a nice result in court. And so they have, sometimes what happens in these mediations is that the lawyers want you to talk the client off the cliff. They don't want to talk the client off. They don't want to go to the client and say, no, you're not right. You're not so right. There's two sides to this. You could lose this. The lawyers don't want to be the ones to do that. So they want to be.
Sounds like you're helping them save face a little bit so that they can run their process, you can run your process, everybody gets what they need. Is that right?
Yeah, that happens quite frequently in these mediations. Not all the time, but quite frequently. Sometimes it's the client who is really driving it, and the lawyer has difficulty telling the client, you're not being rational, you're seeking too much, or you're not willing to pay enough, whether it's plaintiff or defendant. And the client's just very emotional about the situation.
I don't know if you can hear me, but my computer seems to have frozen.
I can hear you just fine. Oh. Now you just froze. If you can hear me, your picture froze. I think you're back now.
Okay, I seem to be back. Sorry about that. I missed the last half of your response. I apologize both to you and to anybody watching this who sees this get interrupted. But with a few minutes left, and acknowledging I didn't hear anything you just said in that last half, I wanted to ask a little bit about strategies, about practice, about what you do, as a mediator. What is it that you do that works? What is it that you do that doesn't work? I'd love to hear you talk about your process.
I think there are a couple of major tools that work in mediation. There are a lot of them, but I'll try to pick some of the big ones. The first one is simply letting people tell you their story. Because oftentimes the only one they've told their story to is their lawyer. They haven't gotten to trial yet. They haven't told the judge. They haven't told somebody who is neutral. Their lawyers, they know that's their advocate. That's the person they're paying to represent them. So just letting people tell your story, listening empathetically, and acknowledging it without agreeing with it and saying that it's right or wrong can be very valuable. People really benefit from that. And then you can move them towards the more rational part of the process. I know that you're angry. I can hear that you're angry. I can hear that you feel like you've been taken advantage of. But let's look at the practicalities of the situation. It costs a lot of money to go to court. It's a roll of the dice. Anything can happen. Is there some better way of maybe working through this situation? So that's sort of one aspect. The other aspect that's used in commercial litigation is what we call the evaluative process. And that's where they are hiring somebody who they think has great experience, someone like me with 30, 40 years experience. And lawyers tend to know that they can be a little over-aggressive in their positions and their assessment of the case. And they do look to the mediator, not to say who's going to win or lose, but to sort of tell them if their thoughts about what an appropriate resolution is are a little bit outsized for the true nature of the case. So it's usually telling the plaintiff you've got more weaknesses than you think you have. Maybe you got a good case on liability, but who knows if you're going to be able to get those damages that you think. That seems a little thin. And then maybe the defendant, you may say, you've got some facts, but there's a pretty sympathetic case by the plaintiff. There's a good chance that a fact finder could award them some money, how much we don't know. And by you giving them that neutral evaluation of the strengths and weaknesses of their position, you can cause both sides to reevaluate what's a fair settlement. In other words, just on the cents on the dollar, the plaintiff may think, I've got a strong case. I should be getting 75 cents on the dollar for my claim. I have $1 million claim. I'm willing to settle, but I should be getting around 800,000 because of the strength of my case. The defendant may look at the same facts and say, we've got the better of it. We know we may lose, but we shouldn't pay more than 30 cents on the dollar. So we should pay $300,000. But I can come in and say, you know what, plaintiff, it's not really a 70, 80% chance. It's more like 50, 60. And the defendant, it's not really an 80% chance of winning. It's more like, 50, 60. It's more closer to a 50, 50. And if they listen to your reasoning and it's done soundly, and if they trust you and your experience, that can maybe help them reevaluate what a fair settlement is. Because most people, they're willing to settle, but they don't want to settle too cheaply or too expensively. They want to settle for what they feel is a reasonable evaluation of the case at that point. But they have vastly different views of what's a reasonable valuation. So the mediator can help bring the two sides' evaluations closer together.
So it sounds like you help them get over what you were talking about earlier in terms of everybody being sort of entrenched in their position of, I know my side's right and the other side knows it too. So this class, of course, is about negotiation, it's about decision making, kind of from the perspective of the people in the seats more than the perspective of the mediators. I'm wondering if you have any advice to people who may be future managers, CEOs, entrepreneurs, i.e. future mediation participants. What can they do when they find themselves in some kind of dispute to get the most out of it?
I would say two things. First of all, obviously be thoroughly prepared, because if you make a good argument to the mediator who then transmits it to the other side, it can have an impact. Whatever it is you're negotiating, if you can be persuasive on your point of view, not definitively to where the other person just agrees, but the more persuasive you are, that'll have an impact on the numbers that are tossed around. So one, be very well prepared. The lawyers that are really prepared and articulate strong arguments tend to do better in the mediations. The second thing is, and this just comes with experience, when it comes to moving in terms of negotiation towards a settlement, you don't want to move too slowly, you don't want to move too quickly. If you move too slowly, you could just, lose the faith. The other side will have no faith that a deal can be reached, and they won't make any compromises. But if you move too quickly, that notion of, I'm going to be reasonable and, let me get to where I think this should really resolve itself. You move too quickly, that's not going to be good either. You need to show some firmness. So you need to always keep moving to keep the other side encouraged that it can be resolved, but at a nice, careful pace to try to get the best deal that you can for yourself.
Well, that is some really good advice. I really appreciate it. I'm just going to note the time, and I think I'm going to wrap us up there. But I just want to thank you again for agreeing to talk with me today and let me use this video interview for our course. So I'm going to go ahead and stop the recording now.
Happy to talk about it.